This is the recently conducted exam of UPSC Combined Recruitment Test. This was conducted on 11th of January 2026 for several vacancies such as Assistant Director Corporate Law in Serious Fraud Investigation Office, Ministry of Corporate Affairs, then Company Prosecutor, MC, Assistant Public Prosecutor in CBI, Assistant Legal Advisor in Directorate of Enforcement, and several other vacancies. Let's solve this paper. The first question is, X is caught red-handed while stealing gold jewelry from the gifts of the bride received by her in wedding reception. In the reception, Y, the executive magistrate of the area, was also present. Y can himself arrest X, order any person to arrest X, or commit X to custody subject to the provisions of bail. All the three options are correct because section 40 of BNSS, that is similar to section 44 of CRPC, when an offense is committed in the presence of an executive or judicial magistrate within their local jurisdiction, they have the power to arrest the offender themselves or order any person to arrest the offender, which matches with this one, commit the offender to custody subject to bail provisions. And since all three actions are permitted, so option B is correct. Next question is, a police officer X, while investigating on a matter of house trespass, locates a person who looks exactly same as the person in the video recording that was attached with the complaint, on the basis of which FIR was registered. Which one of the following statements is most appropriate regarding the arrest of the person? A, X may arrest the person without warrant if he has reason to believe. This is correct. X may arrest the person but requires an order from the magistrate and a warrant. Not correct. X may arrest the person but first needs conclusive proof that person is same as the one in the video recording. And D, X first needs to verify authenticity of the video recording before proceeding with the arrest. Under section 35 of BNSS, which is analogous to section 41 of CRPC, a police officer may arrest a person without warrant if there is reasonable suspicion or credible information that the person has committed a cognizable offense. A video recording attached to an FIR is a strong reason to believe the person's involvement, justifying an arrest without a warrant. Conclusive proof in option C is required for conviction, not arrest. The next question is, which of the following parties can file an application for plea bargaining before a court of law under section 290 of BNSS 2023? The options are the prosecutor within a period of 30 days from the framing of the charge, the complainant within a period of 30 days from the framing of the charge, the person accused of an offense within a period of from the framing of charge. Under section 290 of the BNSS, that is plea bargaining is provided where the application for plea bargaining must be filed by the person accused of the offense. The prosecutor or complainant does not file this application. They are respondents to it. So option 3 will be correct. Next question, which one of the following regarding sentence in cases of conviction of several offences at one trial under BNSS is not correct? Since it is asking not correct, option A, the punishment for imprisonment may run consecutively or concurrently. That is correct. While deciding whether the punishments shall run consecutively or concurrently, the gravity of the offences must be considered. That is also correct. In case of consecutive sentences, if the aggregate punishment is in excess of the punishment which the court is competent to award, the offender must be sent for trial before a high court. This is not correct because it is provided under section 31 of BNSS, which is similar to 31 of CRPC, that if the aggregate punishment of consecutive sentence exceeds the punishment the court is competent to award for a single offence, the court is not required to send the offender to a higher court. If the aggregate punishment does not exceed twice the amount of punishment the court is competent to inflict and does not exceed 20 years. That is the language of the Bar Act. So this one is wrong and the answer for it should be this. Let's read the last option. Even if the consecutive sentences of imprisonment exceed 20 years, the sentence, however, cannot exceed the set period. The last option is also correct because the section mentions that the overall, even if the court inflicts twice the amount of punishment that it is competent to conflict, the court is allowed that. But even then, it cannot exceed 20 years. So the last option is correct because it says that the consecutive sentences, even though they exceed 20 years, but they cannot exceed 20 years. The magistrate will have to punish within the 20 years. Next question is, consider the following statements in respect of service of summons on a firm or other association of individuals under BNSS. Service can be effected by serving on any partner of such association. Number 2, it can be effected by a letter sent through registered post addressed to a partner. Both are correct because under section 65 of BNSS, service of summons on corporate bodies and societies is provided. It says that service on a firm or association may be effected by serving it on any member or partner, or by a letter sent by registered post addressed to the head office or principal officer or partner. So both the statements are correct methods of service. Next question is, a sub-inspector who operates in jurisdiction X has been directed with a warrant to arrest a person who has escaped to jurisdiction Y. The sub-inspector reaches jurisdiction Y but comes to know from the local police that the person to be arrested is already seated in a bus to leave the place. Which of the is the most appropriate step for that the sub-inspector may take under BNSS? A, he shall take the warrant for endorsement to Executive Magistrate of Y. No, that's not correct. He shall take the warrant for endorsement to an officer in charge of a police station in Y place. That is also not correct. He can arrest the person directly. Correct. Because section 80 and 81 of BNSS provides for arrest outside jurisdiction. The standard procedure is to get the warrant endorsed by the local magistrate or police officer, but this proviso says that if obtaining the endorsement would cause a delay that would allow the suspect to escape, for example, here he is seated in a bus to leave, then the police officer may execute the warrant without endorsement. So this one would be correct, C would be correct. And the last one is he shall inform the local police of the destination where the bus is headed, will not be correct. Next question, under section 85 of BNSS, when can an order for attachment of property of an absconding person be issued? A. As soon as the information of the absconding person is received in the court. B. Any time before a proclamation requiring the person to appear at a specific place and time has been issued by the court. C. At any time after the warrant for arrest of the absconding person is issued by the court. And D. Any time after a proclamation requiring the person to appear at a specific place and time has been issued by the court. D would be correct because under section 85 of BNSS, the general rule is that an order for attachment of property is issued after the issue of proclamation requiring the person to appear. But there is an exception allowing simultaneous issue if the court is satisfied that the person is about to dispose of the property. But option D represents the standard legal timing, that is after a proclamation. Next question is, when a person who is bound by any bond or bail bond taken under BNSS 2023 to appear before a court does not appear, the court A may issue a warrant directing that such person be arrested. That is correct because under section 92 of BNSS, breach of bond to appear, if a person bound by a bond fails to appear, the court may issue a warrant directing that the person be arrested and produced before it. The language is discretionary, may, and specific to arrest. The second option, may issue a warrant to locate such person. That is incorrect. Shall issue a warrant directing that such person be arrested is not correct. Shall issue a warrant to locate such person is not correct because the section provides discretion to the court. The next question is, a police officer X, while investigating in a financial fraud matter, finds that one of the suspects has purchased a luxury yacht, which X believes that the same is derived as a result of criminal activity and is about to flee to a foreign country immediately. X, immediately with the approval of the superintendent of police, applies to the court for taking cognizance of the offence. Under section 107 of the BNSS, which one of the following steps the court may take? The court may issue a notice calling upon such person to show cause within 10 days as to why an order of attachment shall not be made. B. The court may, by an interim order passed ex parte, direct attachment of the luxury yacht if it feels that a notice would defeat the object of attachment. That is correct because in section 107 it introduces specific powers regarding the attachment of proceeds of crime if the court is satisfied that issuing a notice would defeat the purpose of attachment. For example, in this case the suspect is fleeing or the asset is about to be concealed. It may pass an ex parte interim order to attach the property immediately. However, the next options are: C. The court has to first decide whether the said property is a proceed of crime is not correct because it is an urgent matter. D. The court cannot proceed without a notice as it is against the principle of natural justice. That is also not correct. Next question. X, an inspector of police, was conducting an investigation under section 116 of BNSS for tracing some stolen precious stones like emeralds, ruby and diamond. During the investigation, X finds a drum containing diamonds that he believed was likely to be concealed. Which one of the following can be said to be the most appropriate steps that X may take? First is, X may make an order to seize the drum. That is correct. X may seek prior approval from the court. That is not correct. X may instruct the owner to ensure that the drum is delivered to the police station immediately. That is also not correct because under section 116, power of police officer to seize certain property, a police officer may seize any property suspected to be stolen or creating suspicion of an offence. Here the statement 1 is the direct power, that is seizure. Statement 2 is incorrect. Prior court approval is not needed for seizure during investigation. And statement 3 refers to giving custody to a person via a bond if the property is hard to transport. But making an order to seize is the primary legal step the officer takes. So here A, 1 only would be correct. The next question is, X has been ordered to pay an amount of 25,000 per month to his wife as maintenance under section 144 of the BNSS. X in the meanwhile starts to live with his girlfriend. However, X readily agrees to pay the maintenance to his wife only if she agrees to live with him. Which of the following statements is correct in this situation? The magistrate need not consider the grounds for refusal stated by her. That is incorrect. The magistrate shall first try to reconcile between husband and wife. That is also incorrect. The wife may refuse to accept the condition. That is correct because section 144 of BNSS says that if a husband offers to maintain his wife on the condition that she lives with him, she may refuse. The magistrate considers the grounds of refusal. Since the husband is living with another woman who is a mistress or girlfriend, this is legally valid just ground for her refusal and she is still entitled to maintenance. The fourth option, the wife may be asked to accept the condition as it may result in reconciliation between the parties, is incorrect because the section does not provide. Section only talks about C. The next question is, a police officer reports to an executive magistrate that in the locality there is a pond where a dispute is likely to arise between X and Y regarding the fishery rights on the same. Which one of the following steps shall not be taken by the EM in this case? Since the question asks what is not correct and what is not to be taken by the EM in this case, the first one provides that make an order in writing requiring the parties to attend the court in person or by an advocate is correct, because in section 148 of BNSS, the executive magistrate requires the parties concerned to attend the court. The second option is ask the parties to provide written statements of their respective claims, and the fact of actual possession of the pond is also correct because the parties concerned are required by the EM to attend the court and put in their written statements directly. The third one is without reference to the claims of any of the parties, produce the statements and receive evidence. That is also correct. But the last one, ask the police officer concerned to provide a written statement from the parties involved, is not correct because the executive magistrate does not ask the police officer to collect and provide the parties' written statement. The parties submit them to the court themselves. So if the question asks not to be taken, what is not to be taken by the EM, the answer would be D, as rest of the options are there in the section. The next question is, the in charge of the police station receives information falsifying regarding falsification of accounts under BNSS. If such commission is within the limits of such station, the officer in charge can take which of the following steps? Shall enter the substance of the information in a book to be kept by such officer. This is correct because falsification of accounts is generally a non-cognizable offense. So when an officer receives information about a non-cognizable offense, they must enter the substance in the station diary. They cannot investigate or arrest without a magistrate order, which is provided in the second one, which says shall commence the investigation of the matter with or without the order of magistrate, is incorrect because that is not allowed. They have to take order of the magistrate. The next option is may commence the investigation and shall have the power to arrest without warrant, is again incorrect. The last one is may require the informant to be presented before the magistrate within 1 week of the receipt of information. They refer the informant to the magistrate according to the section. The first one is the correct initial step. This question is based on the general rule of non-cognizable offences. The next question is, X is accused of obstructing Y, a public servant, in the discharge of his public functions when Y was following a thief who was suspected to have taken refuge in a public hall. X was the gate man of the said public hall. So a charge, number 1, shall state the law and the section of the law against which the offence is said to have been committed. This is correct. The law and section should be mentioned. The second one is, shall be written in the language that is understood by the concerned parties, specifically the accused. This is incorrect because the charge is written in the language of the court, not necessarily the language of the accused, though it is explained to them. The third one is, shall set out the manner in which X obstructed Y in the discharge of his functions. Particulars of the manner of the offence, if the nature of the case requires it, is to be given. In this case, obstruction requires explaining how it was done. So 3 is correct. Answer would be 1 and 3. C would be the correct answer. Next question is, X is charged for knowingly selling goods marked with a counterfeit property mark and is brought before the magistrate. Which one of the following is not mandatory to be followed under BNSS? The first one, the particulars of the offence of which X is accused shall be stated to him. That is correct. X shall be asked whether he pleads guilty. That is also correct. X shall be asked whether he has any defence to be made. That will also be asked. That is correct. A formal charge shall be framed. That is incorrect because this offence of selling counterfeit marked goods is likely tried as a summons case, which is punishable with imprisonment less than 2 years. In summons cases that is provided under section 274 of BNSS, it is not mandatory to frame a formal charge. The particulars are simply stated to the accused. So the correct answer would be D. A formal charge shall be framed. Since the question asks what is not mandatory, D is not mandatory. Next question, which of the following statements in the context of summary trial under BNSS is correct? If the accused does not plead guilty, the magistrate shall record the substance of the evidence. That is correct. Under summary trial provisions, section 283 of BNSS, if the accused pleads not guilty, the magistrate is not required to record the evidence verbatim, but must record the substance of the evidence that is provided in statement A. But the next statement is, the procedure of summary trial shall be the same as the procedure of warrant case under BNSS. That is absolutely wrong. A magistrate of second class shall have the power to summarily try an offence if it is punishable with imprisonment for a term not exceeding 1 year. With or without fine is also incorrect. D is, even though it is marked correct here, it is not correct. The sentence that is passed in a summary trial cannot exceed 6 months in case of conviction. The reason is that under BNSS, the limit of summary trial jurisdiction is offences up to 3 years. But the sentence passed usually cannot exceed 3 months. But first one is definitive procedural rule for summary trials. The next question is, which one of the following statements in respect of directions of the Supreme Court in Arnesh Kumar versus State of Bihar is not correct? First one is, directions are to apply to the cases under 498A of the IPC or Section 4 of the Dowry Prohibition Act, and also to other cases where offence is punishable with imprisonment which may extend to 7 years with or without fine. That is correct. The magistrate, while authorizing detention of the accused, is to peruse the report furnished by the police officer, and only after recording satisfaction the magistrate must authorize detention. That is also correct. The decision not to arrest an accused must be forwarded to the magistrate within 2 weeks from the date of the institution of the case, with a copy to the magistrate for the reasons to be recorded in writing. That is also correct. The last one is, under Section 498 of the IPC, a judicial magistrate may authorize detention without recording reasons. That is absolutely incorrect, because the Supreme Court in this case, Arnesh Kumar versus State of Bihar, explicitly directed that a magistrate must record reasons for authorizing detention and must be satisfied that the arrest was necessary. Routine detention without recorded satisfaction is prohibited. The next question starts Companies Act. So in this case, question, consider the following statements in respect of sweat equity shares under Companies Act 2013. The issue of shares must be approved by the company by passing a resolution requiring special notice. That is incorrect, because the Act requires a special resolution, not a resolution requiring special notice, which is a different legal concept under Section 115. In the second one, the resolution to issue sweat equity shares, among other requirements, must specify the current market price of the shares. That is correct. The resolution must specify current market price, consideration, etc. Third one, where the equity shares of the company are listed on a recognized stock exchange, the sweat equity shares are to be issued according to SCRA 1956, Securities Contracts Regulation Act 1956. That is, the context is incorrect, because listed companies follow SEBI Act or regulations, and since statement 1 is definitely wrong, the answer must rely on 2. That means the answer must be this second one. The next question is, which one of the following preconditions is mandatory for a company limited by guarantee to reduce its share capital under Section 66 of the Companies Act 2013? Option A is, the application by the company must be confirmed by the tribunal. That is correct. Resolution must be passed regarding the reduction by the board of directors. This is incorrect. The application by the company must be confirmed by the registrar of companies. That is incorrect. An ordinary resolution must be passed regarding the reduction. That is also incorrect, because Section 66 of the Companies Act mandates that a reduction of share capital requires a special resolution by the shareholders and confirmation by NCLT, National Company Law Tribunal. Next question is, the power of a company to purchase its own shares under Companies Act 2013 is subject to which one of the following conditions? The buyback is 30% or less of the aggregate paid up capital and free reserves of the company. That is incorrect. The next is, the buyback is 40% or less of the aggregate paid up capital and free reserves of the company. That is also incorrect. The ratio of the aggregate of secured and unsecured debts owed by the company after buyback must not be more than half the capital and its free reserves. That is also incorrect. The last one is, the ratio of the aggregate of secured and unsecured debts owed by the company after buyback must not be more than twice the capital and its free reserves. This is correct, because Section 68 of the Companies Act stipulates that after the buyback, the debt to equity ratio, that is secured plus unsecured debt is to paid up capital plus free reserves, must not exceed 2:1 ratio. The next question is, an extraordinary general meeting of the company under the Companies Act can be called by the board on the requisition made by such number of members, having not less than 1/4 of the total voting power, having not less than 1/3 of the total voting power, who hold not less than half of the paid up share capital of the company carrying the right of voting, who hold not less than 1/10 of the paid up share capital of the company carrying the right to vote. This one is correct. Under Section 100 of Companies Act, the board must call an EGM, extraordinary general meeting, if requested by members holding at least 1/10 of the paid up share capital that carries voting rights for companies having a share capital. The next question from Companies Act is, which one of the following statements with respect to content of minutes of proceedings of a general meeting of board of directors under the Companies Act is not correct? It's asking what is not correct. The first option, it shall contain a fair and correct summary of the proceedings. It is a mandatory requirement under Section 118 of Companies Act. B, the name of directors who have not attended the meeting must be recorded. There is no explicit requirement in Section 118 to list the absentees in the minutes. It is asking what is not correct. The answer has to be B. Let's read the other options. The minutes shall be signed by all concerned within 30 days of its conclusion. It is also a mandatory requirement. The appointments made at the meeting shall be included. It is also a mandatory requirement. So according to Section 118, the minutes must record the names of the directors present at the meeting. So B is incorrect. And that is why it is the answer to this question. The next question is, which one of the following statements regarding declaration of dividend by a company under the Companies Act is not correct? This question is from section 123 of Companies Act. The first option is a dividend can be declared and paid out of the money provided by the central government for payment of dividend in pursuance of a guarantee given by the government. This one is correct. Therefore, this is not the answer to this question. Second option is before declaration of dividend in a financial year, a company can transfer profits to the reserves of the company. Of course, this is also correct. Dividends can be declared and paid from the free reserves of the company. Correct. D. The dividends are to be paid to the registered as well as non-registered shareholders of the company. This is incorrect. Therefore, the answer to this question. Dividends are paid to the registered shareholders or to their order or banker. There is no provision to pay non-registered shareholders directly. The company only recognizes the register of members. Therefore, D is the most legally inaccurate statement because the company is not liable to pay an unregistered transferee until the transfer is registered. The standard text of section 123 provides that dividends are paid out of profits or money provided by the government. A little clarification on option C is that there is a general freedom to pay from reserves, but you cannot just declare dividends from reserves unless there is an absence or inadequacy of profits in that year. About option B, previously this was mandatory about transferring profits to the reserves. Now this is optional. The next question is, which one of the following is not a source of funding for the Investor Education and Protection Fund of IEPF under the Companies Act 2013? First option is redemption amount of preference shares remaining unpaid or unclaimed for 5 years or more. This is actually incorrect because it's not 5, it's 7 years. So this has to be the answer to this question because it is asking what is not correct, what is not a source. The second option, mature debentures with the companies. It is a source under 125. Next option, interest or other income received out of investments made from IEPF. This is also a source under section 125. Mature deposits with companies other than banking companies is also a source under 125. Under 125, there are several other sources such as grants by government, donations, unpaid dividend account, general revenue account funds, interest or income, redemption of preference shares, etc., which is also the first option. In the next question, consider the following statements in respect of CSR under Companies Act. First, the CSR committee of a company must have at least 2 independent directors. That is absolutely false because according to section 135 subsection 1, the statutory minimum requirement is 1 independent director at least. The next statement is CSR committee must ensure that the company undertakes the CSR policy. Strict reading may make the second statement false, but the committee formulates the policy, the board ensures it, the committee monitors, but colloquial phrasing might accept the second statement, but still second statement is dubious and strict reading may make the second statement false. Reading the third statement, a company must give preference to the local area and areas around it where it operates for spending the amount embarked for CSR activities. That is absolutely correct. This is exactly what's written in section 135 subsection 5. So the answer to this will be 3 only, option D. Section 135 says about statement 1 is that a CSR committee must have 3 directors or more directors, of which at least 1 must be an independent director. If the company is not required to have independent directors, then they can have 2 directors. So the requirement is usually 1 independent director. Large companies might need more, but the statutory minimum is 1 independent director only. Next question, with regard to the performance of duties by the auditors under the Companies Act 2013, an auditor is not entitled to which one of the following matters? The question is asking not. So first option is inquire whether the transactions of the company which are represented merely by book entries are prejudicial to the interests of the company. This is correct. They are allowed to do this. Second is inquire whether personal expenses have been charged to revenue account. That is also they are allowed to do. Third is provide actuarial services to the company. This is not correct. They are explicitly prohibited under section 144 of Companies Act to do this. An auditor cannot provide actuarial services. That is written in section 144D. They are entitled or they are required to inquire into book entries that is provided in A, personal expenses that is provided in B, and the last option, inquire whether the loans and advances made by the company have been shown as deposits. They are also allowed to do this under section 143 subsection 1. The next question is, consider the following statements relating to Director Identification Number DIN under Companies Act 2013. The first option is, whether individual intending to be appointed as director of the company must apply for allotment of DIN before the central government. Absolutely, this is correct. 143 section 153 requires application for DIN. Second statement, DIN is allotted within 2 months from the receipt of such application. That is incorrect because section 154 states that central government shall allot DIN within 1 month, not 2, from the receipt of the application. The next is, every person or company while furnishing any return under the act must mention the DIN if such return pertains to any director. That is correct. Section 158 obligates mentioning DIN in returns. Therefore, this is bilkul correct. And 27, the answer would be 1 and 3. Next question. Which one of the following statements regarding the power to compromise or make arrangements with creditors and members under Section 230 of Companies Act is not correct? A. Where an application is made by a company or any other person before the tribunal, it must disclose the reduction of share capital by way of affidavit. That is correct. That is why this is not the answer. B. Where the tribunal orders a meeting, the notice of the same must be sent to all the creditors. That is also correct. C. Where the tribunal orders a meeting, majority of persons representing 2/3 in value of the creditors must agree to the compromise or arrangement. This is incorrect because under Section 230, subsection 6, the compromise must be agreed to by a majority of persons representing 3/4, that is 75% in value of the creditors or members, not 2/3 in value. D. Any compromise or arrangement made include takeover offer. That is correct. That is why, because the question is asking what is not correct, the answer would be C. Next question. Which one of the following statements is in the context of registration of a scheme of merger or amalgamation under the Companies Act is correct? A. On receipt of scheme, if the registrar or official liquidator has no objection, it must be registered by the government and a confirmation must be issued. This is absolutely correct. This is referring to the fast track merger that is provided in Section 233. If the ROC and official liquidator have no objections, the central government, the power is delegated to regional director. They register the scheme and they issue the confirmation. The next option is on receipt of a scheme, if the registrar or official liquidator has any objection, the same must be communicated to the central government within a period of 15 days. The option is incorrect because the time limit for objection is 30 days. The next option is after registration of a scheme, the legal proceedings by or against the transferee company pending before any court of law shall be continued by or against the transferor company. That is also wrong because proceedings continue against the transferee, the new entity, not the transferor, which ceases to exist. The next is after the registration of a scheme where the scheme provides for purchase of shares held by dissenting shareholders, such amount shall become the liability of the transferor company. This is also incorrect. That is why the answer would be A. The next question, which one of the following statements regarding SFIO, Serious Fraud Investigation Office under the Companies Act is not correct? A. The SFIO is established by the central government to investigate frauds related to a company. That is correct. B. The SFIO is to be headed by a person who shall be an officer not below the rank of a secretary to the Government of India. That is not correct because under Section 211, the SFIO is headed by a director. The law states that the director shall be an officer not below the rank of joint secretary to the Government of India, not a full secretary. Next statement is the SFIO may investigate into the affairs of a company if the central government feels that it is necessary in the public interest. That is correct. The next option is on completion of the investigation, the SFIO must submit the report to the central government. That is also correct. So only incorrect option is B, and that is why that is the answer because the question asks what is not correct. In the next question, let's match the following with the landmark judgment and the issue raised. First is Kotala Venkataswamy versus Chinta Ramamurthy matches with second option, a doctrine of indoor management. The next is Erlanger versus New Sombrero Phosphate Company matches with duties of promoters. In the next one, Tata Consultancy Services Limited versus Cyrus Investments Private Limited matches with oppression and mismanagement. And Dr. A. Lakshman Swamy Madaliar versus Life LIC matches with 1. That is doctrine of ultravirus. The answer has to be 2, 4, 3, 1. This one is correct. The next question is, consider the following statements in respect of the powers of the tribunal under Companies Act 2013 regarding the application for relief in cases of oppression. The first statement is, if the tribunal is of the opinion that a company's affairs have been conducted in a manner oppressive to any member, it may make such order as it thinks. This is correct. The tribunal may make an order of removal of the managing director of the company is also correct. The tribunal may make an order regarding purchase of shares of any member by other members of the company. That is also correct. So the answer would be 1, 2, and 3. Because under Section 242 of the Companies Act, the tribunal has very wide powers to relieve oppression, such as making an order if it thinks fit to bring an end to the matters complained of, regulating the conduct of affairs, including the removal of managing director under 242 subsection 2H, ordering the purchase of shares of any member by other members of the company. That is provided under 242 subsection 2B. That is the reason why all options are correct. Next question from BNS. Which one of the following statements, according to BNS, is or are correct? In order to commute a sentence, the appropriate government necessarily take the consent of the offender. This is incorrect because under Section 5 of BNS and previously Section 55 of IPC, the government can commute a sentence without the consent of the offender. Second statement is the punishment of solitary confinement should not exceed 14 days at a time. This is absolutely correct. This is provided under Section 12 of BNS. Solitary confinement shall not exceed 14 days at a time when awarded for a longer period. The answer would be 2 only. The next question is, X, a captain of the ship without any fault or negligence on his part, finds himself in a position where he would inevitably run down a boat, C, carrying 10 passengers unless he changes his course. However, by changing his course, he would risk running down a small vessel D carrying 2 individuals, which he may possibly clear. The captain, in good faith, steered the ship away from boat C and towards vessel D, with the intention of preventing harm to the 10 passengers in boat. In the light of the aforementioned facts, which one of the following statements is most appropriate? The answer has to be 18 because it provides the defense of necessity. Earlier in IPC, under IPC it was section 81. Under BNS, section 14 is a mistake of fact. Section 17 is judicial act. Section 18 is act likely to cause harm but done without criminal intent and to prevent other harm, that is necessity. The illustration given here, captain of a ship, is a classic illustration A attached to this specific section 18 in the statute. X entrusted his watch to Y for safekeeping. Y sold this watch to Z without X's consent. Y shall be held guilty for committing which of the following offense under BNS? The answer would be criminal breach of trust. Theft is under 303 BNS that requires taking property out of the possession of another without consent. In this situation, however, X gave the watch to Y. Y had legal possession. When Y dishonestly converts property entrusted to him for his own use, that is selling it, it constitutes criminal breach of trust under 316 BNS. In the next question, the constitutionality of the marital rape exception under the provision defining the offence of rape was deliberated upon by a high court in which one of the following judgments? The answer is Khushbu Saifi versus Union of India 2022. In this case, a split verdict was given by Delhi High Court, and the court specifically debated the constitutionality of marital rape exception, that is section 375 IPC, exception 2 to this section. There were two judges, Justice Rajiv Shagdher, who held it unconstitutional, while Justice C. Harishankar upheld it. The matter is currently pending before the Supreme Court. Next question. Consider the following statements in light of BNS. First is theft accompanied with the fear of instant death is robbery. This is correct. A thing while being attached to earth is also capable of being subject of the offense of theft. This is actually incorrect because theft is of a movable property. A thing attached to earth becomes subject of theft only after it is severed from the earth, which is also given in the explanation to section 303 BNS. While attached, it is immovable and cannot be stolen. Therefore, saying it is capable of theft while attached, it is incorrect. Third statement is robbery committed by 4 or more persons is considered dacoity. That is incorrect because it requires 5 people under section 310 BNS to commit dacoity. Because it asks what is not correct, the options will be 2 and 3. This will be the answer. Next question is, which of the following offences has been introduced in the BNS? The answer is snatching. This is provided under 304 BNS. Now it is newly introduced. It is a distinct offence in BNS. Under the old IPC, snatching was usually covered under theft or robbery, but now under BNS, BNS defines it specifically as non-bailable offence to address the chain and phone snatching menaces that is ongoing. Other than this, voyeurism, affray, harboring deserter also existed in the earlier IPC. Only snatching is the new one. The next question is, which of the following statements is or are correct? The Supreme Court of India in Mithu versus State of Punjab 1983 held that there is no rational basis for classifying persons who commit murders whilst they are under the sentence of life imprisonment as distinguished from those who commit murders while they are not under the sentence of life imprisonment. This is correct. The second is, according to BNS, whoever being under sentence of imprisonment for life commits murder shall be punished with death. That is incorrect. The third is, Mithu versus State of Punjab 1983 was overruled in Gyan Kaur versus State of Punjab 1996. This is also incorrect because Mithu's case struck down section 303 of IPC, which provided for mandatory death penalty for life convicts committing murder as unconstitutional or irrational. That is why the first one is correct. But second one is incorrect because the BNS removed 303 IPC. 103 of BNS that provided murder punishment does not retain the mandatory death sentence provision for life convicts because it was struck down in Mithu. The third one is also incorrect because Gyan Kaur had overruled P. Rathinam regarding right to suicide or Article 21, not Mithu. Mithu remains a good law still. That is why only option B that provides one only is correct. Next question is, A with the intention of murdering B, abets C, a child of 11 years, to administer poison to B. C did not commit the act of giving the poison to B. In light of this, which one of the following is most appropriate? A is guilty of abetting the offence of culpable homicide amounting to murder. This is most appropriate. Let's read the other options. A is not guilty of abetting the offence of culpable homicide amounting to murder. This is incorrect. A is guilty of committing the offence of criminal conspiracy. No, this is incorrect because it's a child. A is guilty of abetting the offence of culpable homicide amounting to murder and also committing the offence of criminal conspiracy. No, in this situation, there is no offence of criminal conspiracy that has been committed. Under section 49 of BNS that provides for abetment, a person abets an offence if they instigate a person to do an act, which would be an offence if done by a person capable by law of committing an offence. In this case, even though C C is a child, he is innocent or incapable of the crime because of the concept of doli and capax. He did not commit it anyway. A is guilty of abetment because the abetment of an offense is an offense, regardless of whether the act is committed. That is provided in explanation 2 to section 45 to or 49 BNS. The liability of the offender is not dependent on the capability of the action of the person abetted. Therefore, A intended murder, and that is why A would be most appropriate. The next question is, A instigates B to burn C's house. B burns C's house and at the same time commits theft of property in C's house. According to the provisions of the BNS, which of the following is or are most appropriate with regard to this? A is guilty of abetting the burning of the house. A is guilty of burning of house and abetting the offense of theft. Second one is incorrect. The first one seems correct. A is guilty of abetting the offense of theft. This is wrong. A is neither guilty of abetting the burning of the house nor of abetting the offense of theft. This is absolutely wrong. The first one is correct. The reason is that under section 55 of BNS, it is similar to section 111 of IPC. If an abettor instigates one act, that is burning of the house, and the doer commits a distinct act, that is theft in this case, which is not a probable consequence of the instigation, the abettor is liable only for the act instigated. Theft is not a probable consequence of arson. They are distinct crimes. That is the reason why A is guilty only of abetting the burning of the house, and the option 1 only will be correct. Next question is, as per BNS, which of the following statements are correct? The offense of defamation can be committed against a dead person. Correct. 356 of BNS, explanation 1, that imputing anything to a deceased person is defamation if it would hurt their reputation if living and is intended to hurt their family. The second statement, imputation to anything which is true is an exception to defamation and it is for public good. That is correct. The first exception to 356 states that truth is a defense only if the imputation is made for the public good. The third statement, the constitutional validity of the laws on criminal defamation was upheld in the judgment Subramaniam Swamy versus Union of India. This is correct. So the answer would be 1, 2 and 3. Next question, as per BNS, which of the following statements is or are correct? First is, right of private defense extends to running the risk of harming the innocent persons if such a right cannot be effectually exercised without risk of such harm. This is correct because under section 43, which was earlier 106 IPC, this allows for private defense to extend to running the risk of harming innocent persons if the defender is in a situation that is, for example, attacked by a mob where they cannot effectively defend themselves otherwise. The second statement, right to private defense of body is a right of a person to defend only his body against any offense. This is incorrect because it extends to defending one's own body and the body of another person under section 34 BNS. It is not restricted to only his body. A third statement, right to private defense does not extend to causing death to the assailant if the right is exercised against an assault with intention of kidnapping. This is wrong because this is allowed under section 42 of BNS earlier, which was 103 IPC. It lists specific heinous offenses such as rape, kidnapping, acid attack, where the right extends to causing death. For a simple assault with intention that does not fall under these specific categories, that is rape, kidnapping and acid attack, the right does not extend to causing death. Therefore, only option 1A, 1 only would be correct. The next question is, which one of the following kinds of hurt are designated as grievous under the BNS? Emasculation, that is provided under clause A. Permanent disfigurement of head or face, that is provided under F. Dislocation of tooth, that is provided under clause G, that is fracture or dislocation of a bone or tooth. That is why all the options are correct, 1, 2, 3 and 4. In the next question, it asks, which of the following instances is the offense of theft committed under the BNS? First is, A finds a ring lying on road, not in possession of any person. A picks up the ring. This is not theft. A gives his ring to B for repair. A takes the ring back from B without paying the cost of repair to B. This is theft. A cuts down a tree on B's ground without the intention of taking it, without B's consent. This is theft. A, in good faith, believing that a book belongs to her, takes it out of B's possession. This is not theft. In the first statement, picking up a lost ring because it is not in possession of anybody is at most likely criminal misappropriation, not theft, because theft requires taking out of possession. In the second situation, taking one's own property from a bailee or repairer without paying, intending to cause wrongful loss, is theft because a repairer is entitled to some amount for repairing the ring. This is also an illustration of theft. In the third one, severing a tree on another's land with dishonest intention is theft because only the taking away is not theft. Rather, moving is also a theft, and the moment the person severs the tree on another's land with dishonest intention is theft, and it is also provided in the illustration A. In the last one, taking property in good faith, believing it to be one's own, this negates, first thing, there is no dishonest intention or mens rea, so it is not theft. So the answer would be 2 and 3, option C. In the next question, which of the following judgments discuss the offense of obscenity? This is a well-known judgment, Avik Sarkar versus State of West Bengal. In this landmark judgment, the Supreme Court adopted the community standards test for obscenity, replacing the older archaic Hicklin test. The Central Vigilance Commission shall consist of a Central Vigilance Commissioner and not more than 2 Vigilance Commissioner. This is provided under Section 3, Subsection 2 of CVC Act 2003. A Central Vigilance Commissioner along with not more than 2 Vigilance Commissioners must be there. In the next question, which of the following statements under CVC Act is correct? There are two statements given. The first is CVC has the powers of civil court trying a suit under CPC 1908. This is correct. And this is also given under Section 11 of CVC Act that grants the commission the powers of a civil court, which means summoning, discovery, etc. while conducting inquiries. In the second statement, the director of inquiry appointed by the central government for conducting preliminary inquiries referred to the commission by the Lokpal shall be any officer with a minimum 10 years of experience in the services of Union of India. This is actually incorrect because the strict requirement of minimum 10 years of experience for the director of inquiry is not a provision of the primary CBC Act sections, which defines the director's role broadly. So the answer here will only be 1. The next question asks, the committee recommending the appointment of Central Vigilance Commissioner consists of the Prime Minister? Yes. The Minister of Home Affairs, Government of India? Yes. The Chief Justice of India or a judge of the Supreme Court nominated by him? No, he is not there. The leader of opposition in the House of the People? Yes, that is correct. Section 4 of CVC Act states that appointment committee consists of Prime Minister, Minister of Home Affairs and leader of opposition in the House of the People. The CJI is not a member. So the answer 1 to 4 is correct.